So mother went through, again, cut off again, September, October. It's not until the end of November. She has to pay for her visit because DCS hasn't gotten it set up. And she restarts her visits. And now the visits seem to be more tense and more struggling. But again, she has visits with Tracy Rose. And, I'm sorry, and very important, is then this email comes November the 20th from Mr. Geider to Camelot saying, Mom can't say this, and this. And how mom's making allegations of child abuse, and she can make Delara lie. And how he is now not sent to me, which I was an attorney by then, not sent to Ms. Hubbell, not provided even a copy to her, and tainting the whole approach of these visits. None of that is in this order. And what was most troubling to me with Ms. Stevenson, who is the supervisor over Camelot, is she never read this order. She never read it. She fully admits it. It's not in their record. She didn't read it. And yet she sits up here and insists that this email is the order of the court. And all these things have to be controlled by the mother. And then indeed, they go to this visit in January, and mother says the word homeschool and whispers to the child, and now all of a sudden the visits are stopped. Visits are stopped. And poor Delara, even Delara telling her therapist that she was mad because they stopped the visit for no good reason. The cops were called for no good reason. So everybody here wants to focus on that last visit and all the problems of that last visit. Mom's not acting appropriately. Mom's the cops are being called while they're in the vestibule. Mom's not telling them, let's go talk about it someplace else. Even the child thought it was stopped for no good reason. And they want to talk about the past, and mom doesn't follow the court orders of the past, but she followed the court orders of having that therapeutic supervised visitation. Nobody at the end, and you heard her also say she didn't even get a copy of these records. They didn't provide her any of this. Ms. Stevenson didn't proffer any testimony that said that we gave her a summary of what she needed to do or what she needed to accomplish. They never gave her this email. They just manufactured and created all these restrictions on mother that were not appropriate. Sure, mom's frustrated. She's getting very frustrated with this process. So, and she said she tried to have a communication with Camelot at the end of August, and her understanding was they were done. So she goes to the school to see her daughter. That's not a visitation. That is going to a public place. There's nothing in here that says she doesn't have non-custodial parental rights to try to see her daughter. They throw down a restraining order. Then they come to court and they go, well, we don't need a restraining order. She thinks she can go to the school. And then they go to a DCS meeting. We're going to stop visitation. They file a motion. We try to get to court. We have been trying to get a court hearing on this. And I submit to you, had we gotten our court hearing October the 31st, is that when we were here? Had we gotten our court hearing October 31st, all of this other stuff after there would not have happened. And the stuff on the record would have been that the visits had gone well for June, July, and August, and she'd been cut off for 2 months. But they delayed it so they could create chaos. It's just a matter of creating chaos. So I just believe at this point, the therapeutic visitation needs to stop. I think that she needs to have, at a minimum, the visits within this order. I think that she needs to meet with Dr. Berryman with Delara so they can talk about, what are the issues that they should and shouldn't discuss as part of this process. You've heard Dr. Berryman said they didn't even bring it up yet. Well, Delara has never been given that opportunity to know, mom isn't going to talk to you about these things when you're together. So we need to get Dr. Berryman and the child and her mother together so they can start going through this process. This is a child who is struggling with something, and after all this time, nobody seems to know what it is yet. We don't know. Now we're just now saying, well, maybe she has emotional issues. I mean, it's very troubling. She's suspended at 3 o'clock today, another day from school. She's been suspended some 12 days this year. None of that's attributed to the mother, but nobody's also said that this mother's contributed to it. So I think that's where we need to go today, right now. We just need to move on. Thank you.
Your Honor, Ms. Regularly says nobody said the mother's contributed to it. Let me be the first to say that. I absolutely think the mother has contributed to this child's behavioral issues. It is completely ludicrous to act like if we would have come in here on October 31st, that we're the ones delaying this hearing and delaying it. We're the ones that filed, Your Honor. We filed the petition because of all of the behavioral issues that have been going on, of all of the issues that have happened at visitation, of mom sneaking behind the court's back to go out to her daughter's car to see the child unsupervised, of her going to the school. She cannot sit here and act like she did not know she was supposed to go to the school. She knew very well. It was discussed at DCS meetings. It was in the order. She knew very well she was not supposed to do that. She knew very well she was not supposed to be going to the child's daycare to try to get her out of daycare once dad dropped her off. That's why she posted about it in her secret Facebook group and said, if anyone mentions this, I'm going to know there's a hole in the page. Your Honor can read through all the posts that her counsel put into the record, so Your Honor can get a feel for exactly what she knew she was not supposed to be doing. She has continued to violate the orders of this court since 2014, Your Honor. Nothing has changed since the contempt petition. She has continued to violate, and now her violations are having a serious effect on Laura. It is laughable to sit here and pretend like when mom tells the child and posts things about how she's going to tell the child. Now, she claims she didn't have to tell the child, but she posts she was going to tell the child to just refuse to go to school, tells her that the students and the teachers, that they're her oppressors and that we have to fight our oppressors. It is laughable to try to act like there is not a correlation between the things that mom has posted she is going to tell the child, and then this child now, surprise, having behavior issues at school. Now, she's always had some behavior issues. We know that. We knew that she needed to adjust to the school, to the public school system, and that's one of the reasons that we pushed for public school. There were obviously some issues when last year, after she got taken away from her mom, but not many that Mr. Guder knew of. As Dr. Berry would testify, she didn't think he knew of very many. The issues have clearly increased significantly since the visitation, supervised visitation happened, Your Honor. Now, Camelot initially did not know exactly what she was and was not supposed to be saying to the child, as he was testified. That's probably a good reason why there wasn't more of a pushback from Camelot at the beginning. But even in the very beginning, when they didn't know what they were supposed to be keeping her from saying, there were notes made by the supervisor about how controlling she was and about how she was saying inappropriate things when they didn't even know those were the things they were supposed to be keeping her from saying. And they still recognize them as inappropriate. Now they're coming in and acting like this Judy woman who is the supervisor and has told them, oh, you're fine, everything's good. Judy had a lot of issues with her supervision. She was taking phone calls talking about other cases while she was supposed to be supervising these visits. You heard from her own boss that she was removed from the case because of the things that she was doing while she was supposed to be supervising these visits. It was never given by anyone formal at Camelot that these visits could be done. It's DCS's fault, it's Sinan's fault, it's everyone's fault but Lydia's that she didn't get those visits. First it was that he was keeping her from the visits, then it's that DCS didn't get it scheduled. Everybody's fault but hers. The point is, Your Honor, she continues to violate. She cannot even be trusted to do supervised visits. And no, we're not just saying, oh, look at this most recent one. I would ask, Your Honor, to look all the way back to everything that we mentioned in our initial petition as the reasons that this case had to come. Not just this most recent visit, but the things she was posting that she admitted on Facebook she was saying during these visits. The way the child has been behaving at school since these visits have occurred. Tracy Rose, the supervisor before Latasha, tried to end a visit. That's the whole reason Latasha got brought on to supervise these visits. The very first supervisor made notes about issues with Mama. I by no means am asking you to look at just the most recent visit. I beg you to look at the history of every visit that she has had and the history of everything that's alleged in that initial petition and what's been proven today. She is encouraging Delara to fight this corruption, to sit there, the police officers, and wait till that 1:30 mark hits so she's gotten her 2 hours, Delara is about to be unleashed upon her oppressors. In no way can I even fathom how this would be healthy for an 8-year-old child. You're right. She cannot be trusted to do supervised visits with this child. It is insane to think that she can do unsupervised visits.
Ms. Mack?
Good afternoon, Your Honor. As to the issue of whether or not my client, Delara Dare, should be able to testify, I believe the proof is clear based on Dr. Berryman, Dr. Casey Cart, the school psychologist Casey Cart, and even evidence by the child's behaviors, as my colleague, Ms. Regula has stated, she has some significant behavioral problems. I don't believe, or we don't even know what to expect if the child were to come into the courtroom and have to testify. We've had situations where this young lady has had to be restrained, Your Honor, and she's 8 years old. No one has, Dr. Berryman has stated today that there's no reason verifiable for provocation of what Delara's behaviors are. Maybe she's oppositional defiant, no one clearly knows. She's in the process of being evaluated, and it is in this guardian ad litem's belief that it would not be in her best interest to testify that these behaviors may escalate if the youth does not get what she wants, because if she locks it in her mind that this is going to cause me to get to see my mom more or less, and then she doesn't get the result that she wants, I don't know. Dr. Berryman can't tell us, school psychologists can't tell us if it's going to be helpful or hurtful to her. I believe that it is wrong for anyone to let us gamble with her emotional developmental needs at this point in time, to have to bring her into this courtroom and sit, even if she didn't have to talk in front of her parents. The mere thought of knowing that she's going to be talking to this judge about what she wants, and if what she wants she doesn't get. You've heard Dr. Berryman say it, you've heard Ms. Cart say it, when she doesn't get what she wants, things happen. and it is clear. I type in Delara so much to her mother. When she doesn't get what she wants, there's a demand put out, except for I've never known Ms. Hubbell to get violent. I've never known her to threaten anyone, to do anything, to harm anyone. That's why I asked Ms. Stevenson, did she say anything threatening? Can Ms. Hubbell be argumentative and be offensive to everyone that she talks to at some time? Yes. But we know that. We've dealt with Ms. Hubbell now for over 2 years. But as to Delara, the issue solely as to whether or not she should testify, I believe the proof is clear that it would be detrimental to Delara for her to do so. And the court should not even try to take that risk of having to restrain her. I believe Delara law enforcement had to be engaged, school security had to be engaged for her episode today. And I know we're at the juvenile courthouse, but I don't want my client to be exposed to this place. And I believe that if we get here and she decides to kick and rant of Ms. Reese, after learning that Ms. Reese is the person that helped her father get this, I don't know what Delara may do, because she is a very sweet girl, but she can show her anger. I feel like we will be putting this court in a situation to give my client something that I don't believe that she deserves quite yet. And that is the opportunity to visit the juvenile center back there if we can't get her under control. As to that issue, so I do not support at this point in time my client being able to testify. I believe that it is in her best interest that the court communicate in regards to her attorney ad litem, her school psychologist, as well as her Dr. Berryman. We are the most effective communicators that I believe Dr. Berryman clearly said. Delara hasn't said to her one way or another about her wanting to testify, or clearly hasn't said one way or another about wanting to go home with mom or anything. Delara just hasn't hit that. And so ultimately, as to that issue, Your Honor, that is our position. But if the court decides, we already have a recommendation from Dr. Berryman that it happen outside the presence of the parents. Two, the second issue is whether or not mother should step up until unsupervised visitations with the youth. You've heard testimony from Ms. Cart, you've heard testimony from LaTasha Stevenson, you've heard Ms. Hubbell. Ms. Hubbell is actually our best witness. Hands down, Ms. Hubbell is our best witness for what Ms. Hubbell's going to do and when she feels like it, and just clear that if there's an injustice, Ms. Hubbell is going to fight her way through in spite of the fact that her fighting this injustice in the inappropriate way is affecting Delara and also affecting her progress, her individual progress in regards to moving to those supervised, unsupervised visitations. The court order, we can say tomato, it's clear, it's not clear. Ms. Hubbell has never, since that order went down, she's come back maybe for clarifications in regards to some things. Ms. Hubbell filed pro se on her own, even without misregulated things to clarify in the order, if I'm correct, as history would show, even before the case went up to appeal. And so if there was something Ms. Hubbell wasn't clear about, she never said that she was not clear about, hey, once I do these two months, I can move to unsupervised, and that's that. She's never said, come into this courtroom and said, hey, I'm not clear as to whether or not I can go to the school and have lunch with her. She's never communicated that, not to the Department of Children's Services. No one's here to testify to that. Camelot, there's not been any proof of that. Ms. Hubbell, all she has is today, I wasn't clear and I wasn't for sure. But yet, one thing she is clear, there's been an injustice. There's been a disservice to her, and she's fighting for what's best for Delara. But yet and still, when someone tells her, here's where we are, Ms. Hubbell, this is what we need to do to try to move forward, we're still stuck in the past. Even with so much as telling a child that it's her father's fault that she hasn't been able to see her for a year. On the first visit, you get to see her after an order of protection is lifted. That's what you tell your child. Your Honor, I find it struggling as a guardian ad litem, but even just as Ms. Hubbell would say, I don't have the authority to tell any mama, her as a mother, what to do. I beg to differ that Rule 40, as she's told me very clearly, gives me that jurisdiction to make what I recommend and call witnesses and present proof. I believe Ms. Hubbell is the best proof that we have as to what is in Delara's best interest by her conduct in court, by her refusing to follow these court orders. However, is it helping my client Delara not to be able to see her mother? I would say to you, Your Honor, it is not. I don't know how we can orchestrate some kind of plan for Delara to be able to see her mother on a regular basis outside of in front of Dr. Berryman. If we could get Ms. Hubbell to just hear that, hey, stop talking about the dad, stop putting down everybody, and help focus on loving your daughter. Focus on giving her that great time of mommy-daughter time. Leave homeschool, even if it wasn't an issue with homeschooling, just to even keep going backwards. It's showing her living in the past. If we could just get Ms. Hubbell to say, you know what, baby, that's the past. Let's work, let's get this, we're gonna do this. Let's be empowered, let's be encouraged. I don't know what service you can put in regards to that. Because the department, their last recommendation was to do a functional parenting assessment. We don't have concerns with her loving her daughter. We have concerns with her understanding what harm psychologically it could cause to Delara with the things that she's saying. Even before where Ms. Hubbell has even said, I'm willing to go to jail for what I believe in. Not even being concerned with the fact that we all argued that it wouldn't be in Delara's best interest to know that she was in jail. Even after being found guilty of 19 counts of contempt. The father who she says that she hates and who has done these things, but in one voice she loves and she supports her daughter loving him, but yet she tells her daughter something different, says, I don't want to see her go to jail. So I don't want the 190 days that she should serve on her own admission of guilty. Ms. Hubbell, I don't know what we can put, Your Honor, in place. But Ms. Hubbell says we don't have the jurisdiction to do so anyway, because there's no risk of harm to Delara. I would beg to differ. Psychological harm is clear that we are at a risk right now for this child to understand that any further pressing her about what somebody else has done and what somebody else has done, Delara don't need to hear about how the adults have failed her anymore. She just needs to hear about how great of a kid she is and how successful she can be if her mom and her dad will learn how to co-parent. Your Honor, I believe when this case originally began, we talked about some co-parenting. They went to maybe a session or so or completed a class and nobody felt like they needed ongoing co-parenting. Well, it's clear, it's obvious they need ongoing co-parenting. I don't know who can provide that. And I believe Dr. Berryman will be conflicted in providing that service. But at this point in time, as to the issue of whether or not the mother should have unsupervised visitations, I believe the proof is in the pudding. Ms. Hubbell has presented herself to say, I'm ready, but if you don't tell me, if I don't like what you say, I ain't gonna do what you're gonna say, tell me to do. She said it time and time again, even before Ms. Regulate, even after CASA was involved, to say, Ms. Hubbell, all we need for you to do is stop talking about the issues with the case with your daughter. Well, I believe it's an injustice. I believe it's a disservice. This is the history that we've had with Ms. Hubbell, Your Honor. And for the purposes of the record is, she's consistently violated the court's orders, even if there was a dispute about whether or not homeschooling should not have been said. What a reasonable parent, I believe, as guardian ad litem should have done, would say, you know what? Let's step out and let's talk about this in an appropriate way. Instead, we have a child wrapped around her mother and almost rising to a domestic situation. Almost putting the child, again, in the middle of another domestic situation where, again, that's where the order of protection arose from originally, was a domestic situation that occurred in the presence of the child. We need help. We need help, Your Honor. And I don't know what the court can do, but at this point, other than Ms. Hubbell being in some intensive, and I can't even say parenting, because I don't believe it's a parenting issue. I just believe that it's learning how to appropriately, or just leave it alone, not even touch that subject. I don't know what service, the Department of Children's Services is saying they're filing a motion to be done with the case. So who else do we go to? We're talking about mothers, she had to pay for her to have that visit at whatever she had to visit with. Well, originally the plan was for her to have the visits with Life Care anyway. The Department of Children's Services didn't have to even be involved in this. But the mother came to court through her attorney, Mr. Freeman, and said, my client can't afford those $50 an hour or whatever the sessions were. So we did all of this to help the situation. But Ms. Hubbell says, I haven't provided any harm to the child. You shouldn't have gotten involved. But we've done everything to help, and yet she continues to be Ms. Hubbell.
So I just have to respond to a couple of these things. First of all, for a court to limit a parent, it's not just risk of harm, it is a risk of substantial harm. That is the legal threshold which the court has to put such severe restrictions on a parent. And that nexus has not been met today. And, you know, Ms. Rice is going to say, yeah, she's absolutely the cause of the child's behavioral problems. And if you go through these behavioral calendars, this documented evidence of what the child is doing on a day-to-day behavior, when that child has been cut off from her mother because the father failed and refused to continue to cooperate during the months of September and October and November. And look at these calendars. She has not seen her mother in November for over 2 months. She hits 3 children. She shoved another child. She put bread in another child's hair. She hit another boy on another day. She attacked a boy on another day while he was reading and threw sand in a child's face, knocked another child over on the playground. And this is all while, and she was suspended for 3 days that month. There is no nexus. Even Miss Berryman, the professional who came here, said, I can't draw a nexus between the mother in any way. She can't, whether it's the mother, lack of seeing the mother, or the mother doing anything that would be causing this child any anxiety. There is absolutely today no evidence on the record of a nexus between mother's seeing her child or mother's conduct or mother's behavior or what mother's saying that says it's causing the child to act out. There's none. You know, Ms. Rice wants to make a big deal about the Facebook posts. We've already talked about how he got them and what they're for. It's a private group. She has a conversation with him. There is no proof on the evidence that any of that has affected the child. And, you know, the Court of Appeals has issued an opinion on that. What a parent says on social media may not be nice, but unless you can show a nexus that it has affected the child, then it's irrelevant. There's another case, a case I was involved in that, you know, mother was saying, dad's saying horrible things about me. And it goes up to the Court of Appeals, and the Court of Appeals says, well, you've not shown a nexus that any of those bad things that the father has said about the mother has affected the child's relationship with you, because it's clear the child still loves you. There's no nexus here between these things. And so therefore, there is absolutely no showing of substantial harm to this child by being around her mother, and there's none. So we need to get past this. She needs to have time with her mother. And if you sit down and you look at this in December, after she got back with her mom, she has almost a whole week that she's good. So again, I can't say that mom is improving it, but definitely we have a child at risk. She needs both parents involved.
All right, I guess in order to read the records and the things, I'll take it under advisement.
Okay, thank you, Judge. And just let me ask you for a technical, do I bring those 2 exhibits and just give them to you? How do you want me to get those? Just file them with the clerk, put a cover on it or something to get them to you for the, okay. I will do that.
Oh, like to announce an order versus write an order? Are you all available to come back next Tuesday? 21st?
I'm not, Your Honor. No, no.
I'm gonna have to, and I have to call my office, real quick on that, but you're not anyway, but. Anybody's there.
Any other day besides the 21st, Your Honor?
I'm looking. You can't come anytime.
Are you at the
No, no.
office? Okay, I need you to pull up my calendar.
I'm sorry, do I have anything in the afternoon, March 3rd? I don't have my calendar.
Look at the 23rd.
Yes, ma'am.
In the afternoon?
Oh, hold on.
I'm here that day on the 23rd for 2 trials. I'm sorry, Your Honor.
I'm thinking of another day. I wouldn't forget to do
I'm here on the
What's
3rd.
that?
I guess, I think the 23rd.
With her.
Are you available on the 23rd, Ms. Rice?
What time?
I'm not available on the 23rd.
You
I've got
said you're
2,
not
I've got 2 hearings. Morning and afternoon.
Are they here in the building? Are they here in this building?
They are.
Can you take a 5 minutes?
I don't want to, but I can.
What do I have on the 23rd?
I am in,
I think I have
I'm
Woods
sorry,
that morning.
on the 23rd, I am in,
Do I have
that's
anything in
March
the
23rd, I
afternoon?
do apologize, Your Honor. I'm in Rigsby, morning and afternoon.
November 23rd?
Mhm.
Would it be afternoon, Your Honor?
Have to be morning.
Morning, we have the order of protection continuation appeal.
Oh, okay. How long do you think that'll take?
I
It's
don't
not the order
know what-
protection, it's contempt.
I apologize, the contempt appeal. I don't know, whatever we're on docket, it's set for 9 AM, so
I think we're last.
What?
You need to get there by 9.
Oh, I know, yeah.
And I'm in Third Circuit that morning. Yeah, I'm on the 9 o'clock docket. I could probably do something in the afternoon.
Oh, my God. Alrighty. Are y'all available on March the 7th,
What do I have March the 7th?
right after the motion docket, around 10 o'clock?
What is? Oh, I've got, is that at 9? I've got a Williamson County hearing that day. I mean Wilson County.
Alright, looks like I'm going to write it. Yeah. trial in May,
May, yeah.
March 14th,
How about March 14th?
like that.
That's fine for me.
It'll be around 10 o'clock.
March 14th, can you do that, Shirley? Can you do
Oh, I'm
that?
sorry, what?
March 14th.
At what time, Your Honor?
Around 10 o'clock.
10?
Mm-hmm.
Yes, ma'am, I can do that.
All right, let's do March 14th, 10 o'clock.
Okay, thank you.
I'll be ready to announce my decision at that time.
What do you know about her getting suspended this morning?
If you promise not to be argumentative with me, I will tell you. Okay.
I'll just listen.
Okay. Okay. Hold on. They reported that this probably was about 9 o'clock. She started escalating, and yeah, she started escalating and became violent in Casey's office, and so school security had to come.
What
And-
happens with school security?
Well,
That
Because
sounds scary
she's-
to me.
yeah.
What did she do when you say became violent? What did she do? Do you know?
How about we talk about this now when the judge was on the bench?
Oh,
Oh.
dang! I'm sorry.
Sorry.
Y'all want to step out? We're done.
I do.
We're done. March 14th, 10 o'clock, and I'll announce the order at that time.
And Your Honor, in regards to the 2 exhibits, late filed exhibits, we'll have those before that day?
Oh, yeah,
Okay.
yeah, I'll get that stuff to him.
She will no longer be practicing family law, I understand.
Hey, wait, just for, no, before you leave for a second, Your Honor. Just because of kind of where we are, and I know that we're talking about not unsupervised, but if we could talk, if the school is aware of everything that's going on, can she be allowed to at least go to the school? And again, just because of where we are with behavior, for meetings and things like that, even if she's not,
I mean, if there's an IEP meeting and the counselors want her to be at the meeting, that would be up to the counselors, but she's not to go there just to do visits.
No, it's not to visit. I think she's talking about to have a meeting
If there's a
regarding her
meeting that the
behavior.
counselors want her at and need her to attend, then she's more than welcome to attend the meeting, but she's not to go there for visits.
and the reason that I'm asking that, Your Honor, is because right now where we are, if the department is no longer going to be providing those, so that's nothing that my client will get.
She's not to go there for visits. If the school wants her there for whatever kind of meetings, or if it's an IEP or whatever it is, then she can go for that, but she's not to go for the purpose of visitation.
Okay.
There's an order for visitation. If she wants to do visits between now and the time I do my order, she can do supervised visits through life care.
Okay, okay.
They have to be supervised visits between now and the next time I do my order.
Like,
Okay, and father will cooperate if they get contacted to schedule those. That order's still in
Well, and then I
place.
have to come up with $60 an hour.
Right.
Ms. Rice, if you'll make sure your client understands, if life care is called, he does have to cooperate with that.
Ms. Marigolette, if you have any issue with life care, y'all call me, okay? Ms. Hubbell, text me.
Okay,
Often.
write your info right there.
I guess I can start up a separate GoFundMe for paying for visitation.
All right,
let's see.
what's the turn?
Would you mind, sir, taking that plug out of there for me? Thank you.
You have my email address already, Ms. Regular, right?
I don't think I've emailed you anything.
That's okay.
Are you about to put a second box for my case?
No.